Well, so I accidentally touched my earbud by accident a little bit, and we lost our whole intro. That checks out, right? Well, whatever. Love you too. Hi guys, it's Kathy. I hope you're doing well. So we get to the verdict today, and we get to the end of trials for a bit. I think. I think we're going to not do trials for a bit. I'm going to do clips for a bit. Trials are just they're too long. So I wish I would have said that in the description. Guys, guys, guys. We get to the verdict, and then bombshell, everything changes. Everything you thought you believed, you didn't. Maybe a little bit came out, and we kind of knew what's about to slap us in our faces, but we didn't. We're not ready for it. We're not. JK and Chinny aren't even ready for it, and they usually are ready for anything. They're like, oh, another defendant spitting on the judge. Yeah, it must be Monday. Nope, not today. You're gonna be what? What did they just say? And it keeps going on. So at some point, though, some people get up to talk at some point, and they don't give them a microphone. And I tried my best. No tasers, no tasers, just words. We're gonna slap them in the face with words to bump up the audio. You can hear it. It's just that part's not the best, but it's still good enough. There's tears. There's crying involved. Don't laugh at people crying. That's mean. All right, let's get going. Here's the verdict. Here's the verdict, finally.
All right, stay ready.
Yes, Your Honor.
Defense ready?
Yes, Your Honor.
I understand the jury's reached a verdict.
Yeah, they all sat there and waited for him to get into the courtroom, by the way.
Because the sentence verdict form was somewhat complicated, what I'm going to do is I'm going to have the clerk retrieve the verdict from the foreperson and bring it to the bench. And I'm going to ask the attorneys to step up here to the bench to review the verdict to make sure it's in good form before I publish the verdict.
Yes, sir.
Okay. All right. Bring in the jury, Mr. Skinner.
Okay, y'all ready? We're ready.
All right, we're ready.
Let's go, y'all. We're ready, y'all.
All right, if everyone please be seated. All right, Mr. Foreperson, I understand the jury's reached a verdict. Is that correct?
Yes, sir.
All right, well, it's a little different than it's shown on TV. I'm gonna let the clerk retrieve the verdict from you for just a moment. And I'm gonna ask the attorneys to approach the bench to review the verdict to make sure it's in good form.
She's holding her hands behind her back so she doesn't slap him. Good job. Way to control your anger. I actually prefer it. Let's talk amongst yourselves.
All right, go ahead, clerk.
Oh, I'm so mad at everybody here. Oh, I'm so mad at everybody here. Oh, I don't believe how mad I am at you all right now. Oh, man. You guys had the perfect opportunity. And you can fix this at some point in the future. You can. But I'm so mad at you right now. Why? Why did everybody not single-handedly type out, hi, Tiffany, and make her say hi back to you today? Oh my God, that would have been so funny. Sorry, I got sidetracked there. I won't do it again.
All right,
That
Mr.
would've been so
Foreperson, would you
funny.
like to publish the verdict or would you like for the clerk to publish the verdict? Do you want her to read it or you want to read it?
She can read it.
That's the choice I would make every time. All right, please publish the verdict.
Yes. In the Superior Court of Hall County, State of Georgia versus Ronald Kevin Henson, case number 2024 CR 921 JJD. As to count one, aggravated assault, family violence, we the jury find the defendant guilty of battery, family violence. Count two, aggravated assault, family violence, we the jury find the defendant guilty of aggravated assault, family violence. As to count three, aggravated assault, we the jury, family violence, we the jury find the defendant guilty of aggravated assault, family violence. As to count four, battery, family violence, we the jury find the defendant guilty of battery, family violence. As to count five, battery, family violence, we the jury find the
Nine votes.
defendant guilty of battery, family violence. So signed foreperson, Gary Miller, March 26, 2025.
All right, any exceptions to the form of the verdict? Ms. Jackson,
No, Your Honor.
Mr. Shapiro.
No, Your Honor.
All right, let the verdict be filed.
All right, it's in. He's guilty. Thanks, guys, for coming out. Appreciate it. I will see you all. Just kidding. Don't worry. We have more. My coffee's here. I have an earbud in. I'm going to press play and walk over to the door. Knowing how YouTube works for me, the video will probably completely shut down if I do this. But I'm coming right back. I'm just walking right there. So here we go.
Ladies and gentlemen, we'll now move to the next phase of the trial. As part of the indictment in this case,
Your Honor, can we approach?
yes, sir. Excuse me 1 second. All right, ladies and gentlemen, and Mr. Henson, let me just confirm, part of the indictment that was redacted was that the state alleged in count 4 and count 5 that you had a prior conviction for battery under the Family Violence Act. And you have a right to have a trial on that. Do you want to have a trial on those allegations? You're saying no, right? All right, and you're conceding that fact? Yes, okay. All right, well, ladies and gentlemen, that concludes your business on this case, and it concludes, let me look at my clerk, I think I can say that concludes your service for the week. So that concludes your service for the week, and we're going to move right into sentencing, and you're welcome to stay for sentencing if you'd like. You don't have to stay for sentencing. If you'd like to leave, all you have to do is just walk towards that door, and the bailiff will let you out, and you hand them your badge. The one thing I would tell you is this: at the beginning of the trial, I told you couldn't talk to anybody about the case. You're relieved of that rule now. You can talk to anybody you want to about the case. Sometimes the attorneys may want to call you and ask you questions and that sort of thing, and you're free to talk about it. My only rule is, if you don't want to talk about it, all you have to do is say, I really don't want to talk about it, and you can walk away and nobody should bother you further about that, okay? But you can talk about it to your spouse, to your friends, to the lawyers, to whoever you want to now that this case is concluded. All right, Ms. Jackson, you ready to proceed?
Yes, Your Honor. May I have 1 moment, please?
Yes. And Mr. Spear, you ready to proceed?
Yes, Your Honor.
Go back to courtroom. Mr. Henson, while Ms. Jackson is making her preparations. Let me go ahead and tell you, we're going to have I'm going to do a post-conviction scheduling order. And should you choose to file a motion for a new trial, you need to do that within 30 days of today's date. And should you file a motion for new trial, I'm going to ask that the court reporter file your transcript of this trial by July 24th of 2025. That's 120 days from today. And we will hear your motion for new trial at 1 o'clock on September 2nd of 2025. And Mr. Skinner, if you would give this to Mr. Shapiro and Mr. Henson so that they can sign it, and I'll get you a copy.
And Judge, if I'm contemplating conflicting the appeal out, I still.
If you ever get a coffee from Wawa and you try to drink it and nothing comes out, they might put a lid on underneath it so that you can't get to your coffee. Not realizing that someone who hasn't had coffee can't figure that out because they're tired. They need coffee to figure that out.
Sign this order nonetheless.
Right. That's just giving everybody notice. One, so Mr. Henson knows he needs to file a motion for new trial within 30 days. And then he goes ahead and schedules the hearing.
Yes, sir.
Judge, just for purposes of the record, I'm going to go ahead and tender in the battery family violence conviction previously, and I just marked it as states 1A. However, it needs to be labeled.
All right, that's sufficient. All right, 1 second. All right, so Mr. Henson, let me tell you about your post-conviction rights. I've already given you this
Just a view is more than enough. A view. I mean, just a view is more than enough.
conviction scheduling order. I'm going to ask the assistant to make a copy for you. But you need, if you want to pursue an appeal, you need to file a motion for new trial within 30 days. You also have a right to file a notice of appeal. You'd have to do that within 30 days of today's date or within 30 days of any adverse ruling on your motion for new trial. And Mr. Shapiro can assist you with that. And if Mr. Shapiro feels it's appropriate to get appellate counsel, then he can assist you with that as well. Mr. Shapiro, I would just encourage you, if Mr. Henson wants to pursue post-judgment relief, that perhaps you file the motion for new trial just as a placeholder and then help him to find new counsel. And then, Mr. Henson, you have 4 years from today's date to file a habeas corpus action. And all of that will be on your sentence, but I just want to make sure I provided you that notice. And we'll give you this written notice about the motion for new trial as well. All right, Ms. Jackson, you wanted to tender the prior conviction for battery on the Family Violence Act as states 1A. Is that what you said?
Yes.
Any objection? Mr. Shapiro?
No, Your Honor.
I just admitted.
How long do you have to? Forget it.
Ms. Jackson, if you'd like to proceed with sentence.
Yes, Judge. And first, I'm going to be having a couple folks who wish to make a statement, if that's okay with the court.
Oh, no.
Shapiro,
No, he is a shit lawyer, but no. So the judge is just saying no, I didn't. I stopped myself. The judge is just saying that you've been convicted. The jury's in. The verdict is in. You're guilty of all these counts. You have 4 years for habeas and appeals. Shapiro doesn't do habeas court cases, and he's certainly not an appeals lawyer. So he has to find a different appeals lawyer to go through an appeals trial. And if he can't afford it, then they'll give him one.
do you have any objection?
No, Your Honor.
All right.
And Judge, at this time, I'm going to call Killian Henson. Does he need to go to the witness stand, or can he come to the bar? Where would the court like him?
Mr. Shapiro, you okay with him speaking there at the bar?
That's okay.
All right. Mr. Ms. Henson, you can stand right there where the victim advocate's standing. We'll get you a microphone. Let's just give him one of those.
Oh my God, look at that, a microphone that you can hand somebody. They forget all about that soon.
And Mr. Henson, you're making a victim impact statement, so I just ask that you direct your comments to the court, not to any party here, okay?
Yes, sir. Judge Deal, my father has stood before you many times. I think you're aware of that too, as you are the judge here. And you've simply given him slaps on the wrist, it feels, with sending him just to drug rehab or places like that. I ask you, I ask that you now, seeing what he has done after he has went to rehab, drug court, and places like that with no help happening, that you do not simply give him a slap on the wrist. My father has hurt me and hurt someone else named Lindsay. And I don't feel like it's fair for him just simply to get the minimal sentence.
Wait till this very last sentence. Just wait.
To this day, my shoulder still has pain from time to time. And I still can feel his hands around my neck sometimes. I have pre-existing PTSD and it made it worse.
Mom gave him that.
I ask that you throw the book at him, so to say. Give him a harsh sentence, because I do not feel like he will learn from anything else. My father has 36 felonies, and he has still not learned.
What?
That's all. Thank you, Judge.
My father, my father has 36 felonies that he still has not learned. How did we not know this? How did that not come out in court at all? He had 36 felonies. What? Okay. He's saying his back still hurts. That's a lie. PTSD, probably, but that's from his mom. He can still feel the hand around the throat. That's true.
Judge, at this point in time, I call Andrea Gibbons to make a statement.
Mr. Shapiro, any objection?
Negative.
All right. Go ahead, Ms.
Judge Dill, I have known Kevin since I was 16 years old. I loved that man more than anything in this world. And he has put us through a lot of pain, me and my children, but this was the last straw. I always let him have an open door with the children, come in when he wanted to. He'd come eat dinner. I tried to stay friends with him, mostly because you keep your friends close, your enemies closer.
Psycho.
But he had my son, would not return him. I went to Hall County and asked for them to please get him back to me because I had custody, and they would not help me.
Liar.
Finally, on this day, I begged for help, and I finally got somebody to listen and go get my son. He has scars on his back for the rest of his life.
No, he doesn't.
From where he was slammed against a brick wall by him.
No bricks were involved.
That man. Who does that to their own flesh and blood, their own child? I mean, it's one thing to whoop your child or get onto them, when they get in trouble. But he scared my son. He thought he was going to die. Like, he's seen him do things through the years. So I regret ever having my kids around him for them to see, because it's damaged them in the long run mentally very bad. He's mentally scarred me for the rest of my life as well. I mean, I'm not the same person I was when I was 16 years old and I met him. And he's got off and got away with so much through the years. And it's time that he has to suffer for what he's done and how he's affected people's lives.
Mom didn't lie on the stand. That was Dad's girlfriend.
Victim. My son, he's always wanted a dad. He always wanted that relationship with Kevin. But for some reason, he had a better relationship with my daughter. He shunned my son because he was a mama's boy. or he wasn't like he
Right.
wanted him to be. So my son tried and tried to be like he wanted him, but that wasn't good enough either. And that's how my son got rewarded for trying to be around his father. You just can't treat a child like that.
Thank you, ma'am.
Judge, at this point in time, I would just reserve my argument for sentencing to follow Mr. Shapiro.
Ms. Jackson, you filed a recidivist notice, did you not?
I did. Would you like me to go ahead and proceed with that part?
I think if you would address that part, not your argument,
That's
but
fine.
just the recidivist notice so that Mr. Shapiro can address.
So now we know the father has 36 felony convictions, not just misdemeanors, felony convictions. So he's been in jail a lot. And we now know his ex absolutely hates him and is poisoning that poor boy against him. And they're both all in. Can you put your pick on the TV in the court? On the TV in the court. That would be so cool. Oh, that's the best I can do.
That as well.
That's fine, Judge. Yes, I did file recidivist notice under 1710.7, both subsections A and subsection C, which was discussed pre-trial on the record. In the recidivist notice, I named 6 previous felonies of Mr. Henson's. I'm going to hand all of those certified copies up now. One is a 2004 burglary conviction. One is a 2007 possession of drugs conviction. One is a 2008 theft by receiving felony conviction. One is a 2014 theft by taking conviction. One is a 2015 crossing the guard lines conviction. And one is a possession with intent to distribute drugs conviction from 2017. So I'm going to be handing up all 6 of those certified copies under that recidivist notice now.
So they don't have to give all of his felonies to make him a recidivist. She's giving 6 to make sure that he's recidivist. That means he's going to get a harsher sentence, but more importantly, he's going to get day for day for his time. No good time, no getting out of jail early. He gets 6 years, he does 6 actual years. He gets 12 years, 12 actual years. 30 days, 30 days.
Any objections to those, Mr. Shapiro?
Yeah, Your Honor.
All right, they're admitted. Can we just mark these collectively as, we'll say states 2A?
That's fine, Judge.
All right, Mr. Shapiro.
Your Honor, I will start off by admitting what I've showed the state it marked as defendant's record exhibit 1. It's just a letter from Kickstart concerning Mr. Henson, where he's at right now.
Defendant's record 1. Anybody have an objection?
No, Your Honor.
All right, it's admitted.
I want you to just relax and know that this judge heard everything. Everything. Things we forgot about. He heard everything.
Judge, I received that from Mark and Doty with Kickstart. Mark was here earlier. He had to run and go, but he sent that over to my office. I'll talk to you a little bit about, I guess I'll get to my sentence recommendation in 1 minute. I do recognize the history of Mr. Henson as well as the harm that he's caused by committing the charges that he's been found guilty of. And I recognize that he's probably caused a lot of trauma to the people around him, including his son, Killian. And I know that Killian has asked for you to throw the book at Mr. Henson. But I do want to bring up, the very real state of our prison system in Georgia, just to, discuss a little bit what would be an appropriate sentence,
It's a
and
nice
also
shower.
to at least articulate to the court that I don't think any sentence in our prison system is a slap on the wrist. And so I think any time that this court gives to Mr. Henson will indeed be time that he is serving day for day, as this court's aware, based off the recidivism, and that none of that time will be easy nor a slap on the wrist. And so the first thing I would like to point to is the defendant's history. While he does have a recidivist history, I would like to note that none of his previous history does involve convictions for crimes of violence.
Except, why do people keep lying in this courthouse? Why?
I do obviously note that he does have the previous 2010 battery against Miss Givens, but that was at this point about 15 years ago. His last conviction being, I believe, in 2017 for selling drugs or possession with intent to distribute. And so I just want to contextualize that history in the light of nonviolent history, Your Honor. We've got multiple people here in support of Mr. Henson that I know will want to speak, and I'll give them an opportunity. One thing I would like the court to keep in mind is I know Ms. Givens did give her version of what her relationship has been like with Mr. Henson and the damage that he has done, according to her, to him being Killian as well as her. I do think that the custody issue that she's referencing, while not relevant for Your Honor, or not relevant for the jury, what that goes back to is at some point there were allegations made concerning actions against Killian Henson, and whether or not those are true or not, Mr. Henson and Ms. Givens did not agree with the custodial arrangements for Killian Henson. And so I think that that background has a lot to do with that. Without getting into the nitty gritty, I think that just has to do with a disagreement as to the appropriate placement for the child. But I just wanted to bring that up at this point. Your Honor, at this
Okay, he's not wrong. The reason those two, the mother, oh shit. The reason the mother and the child said everything they said was because there's bad blood. That's true. But it still happened.
At this point, I'm going to have multiple members of Mr. Henson's family and those that are here in his support to speak, if that's okay, and if they could just come up to the podium.
Is that okay with you, Ms. Jackson?
Yes, Your Honor.
All right. They can come right there to the bar, if that's all right with the deputies. Is that okay with y'all?
It's not okay with me because it's very hard to hear. And I tried very, very hard to make them heard.
So I'm Jennifer Wheeler. I'm Kevin's cousin. He's one brother of me. And I've been around Kevin all my life. I've known Kevin. I've known the bad, the good, the ugly, the hard, all of Kevin. And I'm not saying that his past life should have anything to do with it, because everybody goes to a past, you make your decisions. But I will tell you that, I mean, not totally wrong, I am an upstanding citizen. I have 3 children of my own, 2 that are grown and 1 6-year-old. And there's never, ever been a day, only been on his worst day, that I would not trust my kids with my cousin. Ever. He would never, I understand that he needs to take responsibility for what happened. I picked Killian up that day, I seen, I know. But he would never hurt a child on purpose. He's been there for my kids with their own dads, wasn't being patted out. He's hurt me. He's done things. But I'm asking you on my part to not throw the book at him, because he knows he made a mistake.
Yes, she just stood up and told the judge that he's hurt her.
You know, the drugs were involved. I know it doesn't make it right. But to try to have some compassion, he won't change his life. Yeah, it's a long time. He's had a long history. He's done a lot of stuff. I know that. He's been in rehab. He's been in drug court. He did good for a little while to get out and go back to the same things, just like a lot of people do. But I'm just telling you on my part, like I said, I have 3 children, and they all adore him. I said, oh, yeah. and he would never hurt a child on purpose. He may have been through trauma in his life, but everybody in this room, shall I say, has been through trauma in your life because of something, whether it be a family member, anything. Everybody. And I just ask that you take that into consideration that he wants to change and he's in rehab now. I'm not saying that he should go to prison and that he shouldn't go there his time. But I just ask not to look at him because he really wants to change. I know him. Like I can think he's like my brother, like a cousin.
He's handing me those tissues. Thank you.
Yeah, I know he wants to change. It's just not as easy. I'm not an addict, so I don't get it. But it's just not something. Nobody's with their 5-year-old says I would go be an addict or an alcoholic. And I should take that into consideration because I'm his dad. Thank you.
Yes, ma'am. Thank you.
Is that a
Chris, did you
trigger
want to
word for you, Michael? Growing up.
I'm like,
Okay. And if you could just state your name for the record and your relationship to Mr. Henson, and then also give your statement, please, ma'am. And then you can also give your statement just for the record for your name and everything.
My name is Christina Caldo. I was in the legal sister-in-law, his brother's. I've known Kevin since he was a teenager. And as Jennifer already indicated, I think ultimately what we'd like to convey today is that we ask that the punishment. We're not questioning whether or not he made a mistake, or that he's made many mistakes throughout his life. He is human. As far as, without discussing too much of prior circumstances, I understand that you have in front of you everything you have done, and I would ask that you please review the circumstances of his custody at that time and take that into account. Things have been indicated, previous discussions over the last few days, that he may have been denied access to their son. I think you can see that that is not the case. With that in
The person making all the noise so that we can't really hear her is the freaking judge.
mind, I would like for you to, when making a decision, consider the reality of the stress that those circumstances would have caused an individual, particularly.
Absolutely.
As Jennifer indicated, I have a son as well. My son is a 22-year-old United States Marine who loves his Kevin.
Hoorah, thank you for
He
serving.
considers him a valuable aspect of his life and his upbringing. That kind of influence can't always be bad. Human beings have good sides and bad sides. So I just ask that you consider all circumstances, even those that were not presented to the court during the last few days, when making your decision. And I trust that you will make one that is both just and fair and what will be the best for all people as individuals.
Thank you, ma'am.
Same right here. And if you could state your name for the record, sir.
My name is Clint Allen. I'm a good friend of Kevin Henson. He's actually my best friend. For like 10 years. We've been through a lot of different things, good and bad in between. The history that you have in front of you, none of those things give a real good indicator of the last 10 years of my friendship. I've been in different situations to where my household didn't have power, and he helped contribute money to that power bill last time. I've had situations to where
I disagree. It means the world.
I didn't have food, and he, without me asking, to be able to identify that need and come through as a friend and fulfill that need. There's been times where I've needed, whether it be help fixing something, hauling a vehicle, somebody to talk to, like genuine decency administered from this man. And to hear the history in this particular topic that we're focused on, if we could see it all in the grand scheme of things on scale, there is good that outweighs the bad. There's not a single person in this courtroom whose life is better with him being in prison. It's not. I myself have an extensive record. You know, we kind of walked the same path once upon a time. I had a year clean last week. I'm back in a sober living facility. There's things that we missed whenever we were introduced to you 10 years ago. There's things that we missed. And now that I'm in the situation I'm in life, and I'm being used, God has sought fit to be able to use me in a different type of way than what I was before. And I really hope that there's an opportunity for me to be able to show him some of the ways that we can actually go about this thing, because it's not too late. In the prison system, I've been there too, and I know that back then it was bad. It's even worse now. And there's a certain wicked that goes around a facility like that you have to match that type of energy in order to survive. And it's not there's no positive from it. I don't see a positive from it. He knows what he did wrong. But to see somebody with a heart like his that people don't know about go to a place like that, it just don't feel right. It don't seem right. So just hope that you consider all these things and know that he can still be used for a lot of good. He can still reach a lot of people. Even though
The judge agrees. The judge likes this guy. The judge has known this guy for a long time, and he's a nice guy until he's not.
on the stages probably that he's in, he can still make a big difference, a big impact. Wow.
Thank you.
Your Honor, Lindsay Schubert actually would like to give a statement.
The victim.
So I figured I would go ahead and let her give that statement.
That's right.
My name's Lindsay Schubert. I've known Kevin maybe 5 or 6 years and not known him that long, but I know in the time that I have known him, he's never been anything but the best friend that I could ever have. We had our falling outs, we had our ups and downs, but all in all, I would trust Kevin with my kids. My kids love him. Anytime I ever needed anything, he was always there for me. I didn't have Christmas for my kids one year, and he gave me everything that I gave my kids for Christmas. I mean, yes, we had a bad night, bad things happened, but I've seen Kevin try, I've seen Kevin do, I've watched Kevin draw with Gillian. I've seen so much, and I don't think that throwing the book at Kevin is what Kevin needs. That's not what Kevin needs. I myself am going on a year clean.
He didn't insult her.
Kevin has a good heart. Kevin has a really
Assault
good heart.
her. That's why we're here.
And I just don't want you to see him slap the book, just throw the book at him. That's not what he needs.
This X is where they throw the book at people.
Your Honor, this will be my last witness for sentencing. This is Tammy Casper.
My name is Sandy Casper. I've known Kevin Henson for about 14 years. We dated a couple of years. Kevin's a good person. Kevin and I never had any arguments. Kevin's had a long history of drug history and doing wrong. Kevin needs rehab. Kevin needs help. If Kevin goes to prison, there's going to be all kinds of drug and he can do anything he wants in prison. I would just ask the court, think about, and he's already in rehab. We've already paid the money for him to be there. Just have mercy on him. He's a good person. He doesn't deserve prison time. My son, Daniel Hendrick, went through your program a couple times. And I didn't think Daniel would ever change. I really didn't, but he did. And Kevin needs that same chance. Because if he goes to prison, he may not come home.
Thank you.
Your Honor, the next thing that I forgot, Mr. Henson, would you like to speak at all to the court? Mr. Henson.
All right. Who Who thinks Mr. Henson is going to speak up for himself? So yesterday we knew he wasn't a great guy, all right? But we didn't know that he's been a convicted felon for forever. And he has an abuse charge in the past. We didn't know any of that. None. Well, he's about to talk for himself. And it explains a lot. And then we hear the judge. And the judge knows everything. He's going to give us all the tea.
Your Honor, Mr. Hanson can go ahead and give a statement.
They are extremely worried about that. And they should be. His whole family and his whole team over here, even his lawyer, honestly feels like if he goes to jail, he's never coming home. Because Georgia jails are no freaking joke. They're no joke. There's deaths all the time. And he's going to, if he goes to jail, who knows what's going to happen?
I'm a little shocked right now. Well, to start with, I never had any intention for any of this to happen. But that rested on your jury. But you've got some experience with me, Judge Dill, as far as my time in the program. And I feel like I thrived during that program. Like Clint said earlier, I feel like there were some things that I may have missed. And quite frankly, I wish I would have slowed down and paid more attention and maybe latched on a little more. And I'm not upset at anybody in this, I'm wanting to take responsibility for what I did.
You took it to trial.
I'm in shock right now, but I too feel like if you would give me a chance at some type of recovery, I'm already starting it, and I understand that's a long shot. But just like when you let me in the program, that was a long shot too. And I told you to give me a shot, and I would show you. I couldn't tell you about it. And then really, I'm just asking to have some mercy on me here today, because there's extenuating circumstances that go around this, and some of the documents that I was unable to provide before, I've found since then. So I just hope that you'll take your time, and if there's anything that I can give you as far as documents to show that everything is not what it seems on black and white. There were a lot of circumstances around this that created a lot of animosity, a lot of crazy thoughts in my head at the time. I was dealing with a lot of stress myself, for me and my children. And to be honest with you, I'm still learning how to deal with some of that stuff that impacted me and my children's lives. And unfortunately, on that night, some of it spilled over and it showed its face, and my son got hurt. And I'm sorry for that. But I think that's all I've got to say.
Thank you.
Judging with that, what I'll be asking for, I'll start off with Mr. Hanson has served in custody from November 27th, 2022 till March 7th of 2023. And then
I'll say that one more time slower. 27 November 2022.
Yes, sir. To March 7th, 2023. And then he was booked in when the charges were transferred to the district.
He said, and my son got hurt, I'm sorry for that. He didn't say, I'm sorry for hurting my son. That's not what he said.
Attorney's office, he was booked in for an additional 2 days from April 16th to April 18th of 2023. And then I believe the only thing I need to figure out is he was rearrested on that warrant. So he did spend more time in custody. Do you remember December 4th? Mr. Jackson, do you mind to check your office center?
We can get the dates at the end of all this too and put it in order.
Your Honor, I'll get the further dates in a second. But what I'm going to be asking.
So he has time. He has time that he spent in jail already, and they want to give him some of that as credit. Now, just because he's recidivist and he has to do all of his time, he does still get credit for the days that he served, but it's not a lot.
In this court for is a sentence of 20 years with 2 years to serve, with credit for any time he served thus far, and that following his service of custodial time, that he be ordered to complete Kickstart as well as any treatment that this court deemed necessary, whether that be through an accountability court program or not. I certainly understand the argument both ways as to an accountability court. I know he did have the shot at this once and did it well, but obviously without the structure, just has not done well. And I do believe Mr. Henson when he says that night was stressful, drug-induced, and was a bad night. And the reason why I believe that is because I think during trial what we heard is there was not this history of violence between him and Lindsay and Killian. And so to me, what it does sound like, while it's not an excuse, it does sound like a terrible night and there were drugs involved. But like Mr. Hansen said, and like the jury came back with, there's no excuse to put your hands on your child. And so I do recognize, what he did. But at the same time, I do think that there are other sentences that have been through this court that shed light on the appropriate sentence for this case. And so one case that I was looking upon and just kind of struck my eye, it wasn't a trial I was involved with.
And Judge, I don't know that that's proper to consider for sentencing other cases with other.
I don't know if I agree with her. I think, first off, I'm stoked that he brought up this specific case to this specific judge. She's right though. It's different. That other case is way different than this case, but he should be allowed to bring up other cases. Lawyers do it all the time, all through charges. So I don't know. I don't know about that.
Facts and previous history and all of that type of thing.
I'll give you some leeway. Go ahead.
Just the only sentence I was looking at, Your Honor, as a guideline is Clinton Andrew Smith back in 2022 is what it looks like. And I believe Mr. McNeil tried that case. All to say that defendant had been charged with attempted murder based off of shooting Christina Rosenberg and was convicted of aggravated assault and aggravated battery. And the sentence there was 20 years with 3 years and 6 months to serve, the remainder on probation. And so I just highlight that sentence just as at least some kind of a baseline as to these types of verdicts. Looking at everything that happened that night, and the counts that are in front of Your Honor, while there are 5 different counts, it was a rather brief incident with moving parts. And so I do think that the facts that came out demonstrated that this is what happened and that there are alternative counts. But like, for example, the jury returned a verdict of guilty of battery on count 1 and then also guilty of battery on count 4. And it would be my position that whether those merge or not, counts 2 and 5 and 4 are essentially for the same thing, counts 2 and 5. And so, or counts 2 and 4, sorry.
I hate when I have so many counts that I don't know which ones merge.
And so because, I think some of these facts overflow into one or another, I do want the court to take that into consideration in issuing the correct sentence. And like the defendant said, like Mr. Henson said, he's at Kickstart, and I don't expect him to go complete that program today, but I would like him to have the opportunity to continue that, and just for the court to keep in mind what years look like. And 2 years, 3 years in prison, that's a lot of time. And I know to Kelly and Henson, that may not sound like throwing the book, but it's our position that indeed is a heavy punishment. And so we would ask the court to take that into consideration.
All right, is that it?
Yes, sir.
Ms. Jackson?
Judge, I think Killian Henson said it best when he spoke to the court. He said, "My father has hurt me." And that carries great weight coming from a 16-year-old who experiences hurt at 14 years old. And the only reason that he experienced that hurt is because he was trying to step in and save Lindsay Schubert and protect her. What a bold move by a 14-year-old, and what an honorable thing to do. And yet he ended up hurt, and she ended up hurt, and both of them ended up hurt pretty bad. I mean, to where both had to go to the emergency room, and this jury has found that he has committed at least 2 of those aggravated assaults and a lesser on the first one, Your Honor. And so the severity of the facts, the court heard it this week. The court's seen it through the testimony and through the medical records, and knows how severe those aggravated assaults were.
I can't get over the mom. I can't get over how much the mom has poisoned him. So yes, he was thrown against the wall, but yes, he was 14. But I don't think he was as hurt as they both say that he was hurt, because the mom is just, and maybe he deserves all of her venom. I don't know. We know that he was charged with beating her up too.
And if that wasn't concerning enough, Judge, it is not really accurate that Mr. Henson has no previous violence in his history, because he does have that Battery Family Violence Act before the court. But I will let the court know that while that ended up in a battery under the Family Violence Act plea here in Superior Court in Hall County, it also started out as an aggravated assault against Andrea Givens. And so this is a person who has violence all throughout him, and who is going to continue to act in that manner, under drugs or not under drugs. That's how he is, and his history shows that, Judge. He has, by my count, 6 previous felony convictions. He is a 6-time convicted felon. Things stemming from burglary to possession with intent, crossing the guard lines. The court has all of those up there for your consideration, as well as that aggravated assault reduced down to battery under the Family Violence Act, Judge. And I hear what folks are saying about, he's an addict and all of this stuff. But Judge, at some point, he's done drug court. He's been in a Thor-approved treatment program, and now he's out here committing aggravated assaults against his own kids and his roommates or girlfriends or whatever they want to call themselves. And we all have a past, sure. I am not out here saying that we don't, but at some point, this becomes more than I'm going to blame it on the addiction. I'm going to throw myself on that. At 6 times of a previous convicted felon, and now 2 additional counts of serious aggravated assault. Some accountability, something has to be done, Judge, and there's a reason that we send people to prison, and that's to keep folks safe. And it goes for situations just like this. And so somebody said that they're asking for the punishment to fit the crime. Judge, I am too. This is a serious case with someone who has a terrible criminal history. And I'm asking this court to see past, I've done drug court before. I'm out on bond right now in a Kickstart program, and hold Mr. Henson accountable for what this jury has said he's done. Not to mention the other drug case that he still has pending that he's gotten while he's been out on bond. For this very case.
That happened. That happened. While he was on bond for this case, he picked up more cases.
That is important, and that plays a role, or should play a role for this court. Judge, in addition to all the normal standard terms and conditions that the state usually asks for, I'm specifically asking for no contact provisions with Killian Henson, Lindsay Schubert, and any of Killian Henson's family. And we will submit a protective order form to that nature as well, Judge. My total recommendation for this court, based on everything that I just said, and I'm not going to go count by count, Judge, I'll let the court allocate that out, but my total recommendation with all of those things that I've just previously mentioned is 20 years on probation with the first 12 years to serve in confinement, Your Honor.
So she wants 12 years, and it'll be
All
day
right,
for day.
let's first talk about the merger issue. I believe that count 4 battery would merge with count 1 battery as alleged.
You're about to fall in love with this judge. I'm telling you, he heard everything, and he knows things that they don't know, and he's going to tell us them.
And so count 4 is going to merge with count 1. Count 5 battery, I believe, would merge with count 2. Ms. Jackson, do you disagree with that?
I do on the latter, Judge, not the former. I would agree with the court, but I do think that count 5, the way that it's alleged,
I love that.
Talks about striking her in the head, but it talks about the contusions to the face as well. And so I think that is different than the strangulation alleged in count 2.
All right, Mr. Shapiro, you say anything about that?
I would think they merge just because it still involves the same transaction or act, which is, one incident of strikes to the upper body, head, that area of the body. And so I do think that count.
Isn't it? When we were all 10 years old, did we ever think we would get into a world like this? Look, when we were all 10, all of us here, we got beat by parents and anybody else who thought we were doing something wrong. Anybody was allowed to just beat us to let us know that we're not allowed to do that. I mean, if someone slept over at my house and did something wrong, yeah, my father would beat them. If I went over to someone else's house and I did something wrong, their father would beat me too. We were 10, fast forward all these years later. Can you believe that we're in a place like this where, you can't do that or you're going to jail? All of our parents would be in jail right now. All of them.
5 would merge into count 2, Your Honor.
Those nuns, yeah.
In retrospect, Ms. Jackson, I think you may be right because count 2 is pretty specific about choking and count 5 alleges striking in the face and punching or slapping and punching in the head, resulting in visible contusions to the face. So I'm going to withdraw that. I think count 5 does not merge with count 2. This is hard because I know Mr. Henson. I've known him for, at least since 2018 or so, 2017, 2018, when he participated in the accountability court, and he did fairly well when he was in the accountability court, graduated. And I believe in recovery. There's nobody in this building that can say that I don't believe in recovery. Drug addiction's a relapse and disease, and that's why I believe in giving folks additional chances. I think you've also heard me say, though, that it's different when it starts hurting other people. If you're a drug addict and you're hurting yourself, hurting your family tangentially because of lack of support, being absent, not providing resources, that sort of thing, that's one thing. When you start physically hurting somebody else, that's a whole different story. In this case, Mr. Henson's got an extensive history. I think it's distinguishable from Clinton Smith that Mr. Spiel brought up. He did get a lighter sentence, 3.5 years to serve for shooting somebody. He also immediately drove that person to the hospital and said, "Oh my God, I shot her." And he had no prior history to speak of.
Good job, Shapiro.
Different
Good job.
situation. I will say some things that cause me some concern and aggravation. Is that I believe Mr. Henson was on bond for another allegation of domestic violence when he picked up these charges.
Wait, what? Judge, the lawyers didn't tell you that. How did you know that, Judge?
I think he was subsequently acquitted of those charges.
I believe that's right, Judge.
He was on bond for these charges.
Gotcha. But anyway.
Why? My driver's ed teacher, Mr. T, picked up someone by the throat and put him into the chalkboard. Driver's ed. $1 a minute, Wheatus.
Well, we had a trial in September of 2023 in which Mr. Henson was acquitted. I'm assuming he was on bond prior to that. The case was indicted in June of 2023. The offenses were alleged in August of 2022, so I'm assuming he was on bond. He was acquitted. I'm not holding it against him, other than the fact that he was on bond when he picked up these new charges.
He was. The judge knows.
That gives me some concern about his ability to follow the rules in light of the fact that what's been argued is that he was under the influence of drugs when he committed these offenses, which would have been a violation of that bond. It gives me concern that Mr. Henson's been charged with a new offense since he's been on bond for these offenses. It calls.
Yeah, you heard that right. So he was on bond when he committed those offenses. And now, while he's on bond for these offenses, he got, I think, 2 more cases.
Me grave concern that there was testimony that during the course of time while Mr. Henson was on bond for these charges, that he had not only had contact with his son, but he had contact in which he attempted to influence his testimony.
They mentioned that and we
That's
forgot it.
extremely concerning, because that shows a lack of respect of the rules in addition to this criminal conduct. That being said, Mr. Henson's a nice guy, especially when he's not on drugs. He's a nice guy. But that doesn't excuse his behavior. He was a danger to his son that night. He was a danger to Miss Schubert that night. And there's no excuse for that behavior. And when you start hurting other people, there are consequences. So the sentence on count 1 is going to be 5 years to serve, credit for any time you previously served. Count 2, aggravated assault, the sentence is going to be 20 years with 13 years to serve. Count 3 is going to be 20 years with 13 years to serve concurrent. Count 4, is going to merge with count 1.
Wait a second, Judge. They only asked for 12. The prosecutor only asked for 12 years.
Count 5 will be 5 years to serve concurrent with count 1. Well, since you're under the provisions of 1710(7)(a) and C, finding that you are a 1710(c) recidivist, while you're on probation, you have the following conditions. I'm not going to impose a fine, but you'll pay court costs and surcharges, pay the $50 PD application fee and $300 reimbursement, $700 reimbursement to Hall County for your attorney's fees. You report to probation, perform 40 hours of community service, have a 4th waiver, provide bodily specimens for testing and waive evidentiary foundations. You have no contact with Killian Henson or his mother or his family or with Lindsay Schubert. You'll not harass or threaten those folks. You'll enroll in, diligently attend to successfully complete the family violence intervention program, provide records releases, undergo evaluation and treatment for substance abuse, attend a minimum of 2 12-step meetings per week while you're on probation, obtain high school diploma or GED and show proof of that to probation, provide a DNA sample as required by law. You'll avoid using or being in the presence of alcohol or drugs, being around others who are under the influence or in possession of alcohol or drugs. Don't be near residence or vehicle in which alcohol or drugs are present. Verify your prescriptions with probation. Be subject to a minimum of 2 drug and alcohol screens per month at your own expense at the direction of probation. I'll add a recommendation that you be considered for REACT court, although I'm not sure how likely that is, because as a recidivist, I don't think you're going to be eligible for parole. All right, that'll be the sentence of the court. I've told you your post-conviction rights. I'd encourage you to continue to work with Mr. Shapiro to deal with it.
I can hear the handcuffs. So he got 13 years. And then he does 7 more on parole. And no good time. He does 13 years. When I had to go up and find CJ's message. I lost it. She needed to wait just 1 more minute. All right. Oh, we made it to the end of the trial. They should have allowed us to know all that other stuff while the trial was going on. You know, especially if he was convicted before of family violence. Okay, so before we go on to the next video, if you didn't know by now, Monday, this coming Monday, I'm going to start my live stream at my normal time, which, you know, is a little fluid, but around 4:30 a.m. And I'm going to do my 2 hours-ish, like I always do, for free. If you want the stream to go any longer than the 2 hours that I give you for free, except for my members who pay, you have to pay $1 per minute. So far, or let me look. So far, we got, Fozzie bought the first 100 minutes. Zach bought 5 minutes. Fletcher got 9 minutes. Springsteen got 2 minutes. JK got, Debbie got 10 minutes. Monica, 60 minutes. And Nan, 50 minutes. And, I mean, I definitely prefer it not come through YouTube because they take it all. But if you want to do it through YouTube, that's fine. If not, there's a, under donation information in Discord, there's my PayPal and my Cash App and my Venmo. I was just gonna get 50 times out of this. Ooh. Music bingo. We can't do music bingo on Monday because I'm gonna be streaming for at least now 400 some, over 4 minutes right now. That's where we're at right now. It's up to 24 hours. I am not going over 24 hours. I'm a person. I'm really hoping we don't get anywhere near 24 hours. But I think my longest stream, Bozzy asked, get out of here. No. I think my longest stream was 7 hours, was it? I don't remember. Yep, there's that. But I would go into Discord, and look at the way down at the bottom, donation information. That's the best place to go. Or YouTube. I don't care. But if you want me to do a longer stream, you got to pay me for it. I'm not even promising good content. That's Lafayette. I miss Lafayette. I miss Lafayette from True Blood. He was like my friend. And yo, that's awesome. And True Blood's been over for a while now. But I do miss Lafayette. If you all didn't see True Blood, it's worth it just to watch Lafayette. No, I can't have a judge as a guest. Oh, my son, maybe. But I can never have a judge as a guest on my show because we do court cases and judges aren't allowed to comment on court cases, and we do comment on court cases. Hi, Bill. Hey, Bill, how's jail? Bill was in jail today, guys. We bailed him out. Oh my gosh, is there a Lafayette compilation? That's awesome. I love him. I love him so much. Okay, now we're moving to
26, which is
we're gonna finish the hour watching I think it's the hardest judge I know in Indiana. I just do. He's the hardest judge I know. And you have to watch her face when he's talking to him, which is talking to him right now, I think. Because she's making these faces because their stories are almost identical. All right, here we go.
prior to the defendant's current probation. Then at 11:49, the defendant telephoned this officer reporting that he was aware of the active warrant for his arrest and claimed that the charges came from his incarcerated Branchville Correctional Facility. Officer director reported to turn himself in. The arrest warrant defendant refused to report in. Defendant stated he wanted to see his family, that he would turn himself in on Monday, January the 20th. On Tuesday, the 21st, the arrest warrant in Prairie County was still active. Defendant was not in jail. Defendant had not reported or turned himself in. Current whereabouts are unknown. So long version, you're absconded is what they're saying. You didn't report as directed. All right. So do you understand what they're saying you did to break the terms of your probation?
I do, Your Honor. I did turn myself in on the 21st of January.
We will enter a denial of those allegations and set you for a revocation hearing on May the 13th at 9 a.m. Let me remind you, you have the right to remain silent. Anything you say, if you waive your right to remain silent, is being recorded and can be used against you. How did you manage to turn yourself in? What was the mechanism for that?
I had somebody drive me up there, Your Honor. I'm done there.
But you just went to Perry County?
I went to Perry County, Your Honor. Yes, I did. And I went to jail and turned myself in.
Okay.
On the 21st. My ride fell through on the 20th when I thought I was going to make it there. My dad's been in and out of the hospital for months, and I've been locked up for 4 years, Your Honor. I ain't seen my grandson in 3 years, so I wanted to see him before I turned myself in. So I turned myself in on January 21st. I'm done there. I got done there this last on the 19th of this month. Time served, no probation. I'm done. Just please have some mercy. Let me try this one more time, Your Honor.
Ms. McCright, what's the state's position today on Mr. Gerard's bond?
Judge, I'm requesting a $5,000 cash only bond. I'm sorry, but refusing to report to probation because it's an inconvenient time is not a valid excuse. The state of the eye is at minimum, so I have to request a $5,000 cash only bond.
All right, thank you, ma'am. Mr. Gerard, I'm going to look up some criminal history and some other things that we've got going. What was the result? Here it is. Here's that Perry County case. Let me look at that.
Level 6.
While I'm looking at that, the Google Picture will change your name to your real name. That'll help you get called a little bit faster.
And Judge, it does look like, according to Bindley, that Mr. Gerard did turn himself in, or was at least booked in to Perry County on January 21st, as he's indicated. It does look like he pled out to a 6 there. And
So no PSI. Kind of wanted the PSI.
Yeah, and the offense predates the placement on probation. He's indicated again that he's got basically a local residence, I think, in Harrison County is what he said, Judge. So I'm going to ask you to order his release to report to probation here, and then if they transfer it to Harrison County, whatever makes that, they're great. Otherwise, if you set a cash bond, judge, and that's supposed to do a court cash.
Right. Thank you, Mr. Abel. Let's see here. Mr. Gerard, I'm reading the probable cause affidavit from the Perry County case because he pled to a 6. That doesn't mean it was still not serious.
He's thinking. Your volume is fine, guys.
Not super worried about that probable cause affidavit. Let me look at the allegation of habitual methamphetamine theft, which is just a version of methamphetamine.
Oh, I've been sober for 2 years.
So, Mr. Gerard, here's where we are. The allegations of the Perry County, we want to call that a battery. I'm not going to call that a case. Let's say predated your probation. So I couldn't revoke your probation on that if I wanted to. What we're dealing with now is that you didn't report as directed.
When I talked to him, I'm sorry, Your Honor.
We know that you didn't want to serve that warrant. You did take accountability for that. So there's got to be some accountability for the fact that you didn't go when you were supposed to, but a recognition that you did go at some point. So I don't know where I land on that, Mr. Gerard. Tell me what else is going on in the world. Here's the thing, I'm sorry, but everybody tells me their grandmother died from cancer. So I don't want to hear
No, that's understandable. Your Honor, look,
No, Judge, what? Everybody's telling me their grandmother's dying from cancer. Everybody. Stop.
I got 2 grandbabies. I've been gone for so many years. Just give me one shot. If I mess it up, look, you can do whatever you want. I'm just asking, please, just at least 10% my bond of 500 or something. You know, Your Honor, I mean, I'm really trying. I got a job lined up with my sister over Story Avenue. I'm sorry. I had a job interview at Friday at Jasper Engines. I had to reschedule that as well. You know, I'm really trying. I've been going to next step meetings when I was out last time. I got accepted in the Grace House in Milltown, and then I had to turn myself in on this case. I had stuff going for me.
Mr. Gerard, I'm going to release you today with the added conditions you violate no laws of the state of Indiana or any other jurisdiction. You're going to get out today. Oh, that's a probation. Hold on a second. You've got a Harrison County open hyperlink, but that's probably just a probation violation. There's a path for you to restart probation. It's possible. But one of the issues you've got to address is your history of substance abuse, whether you're you were talking about whatever house you were going to be at in Milltown. I think if you were to check in there and live there for a bit, you would have a pretty good shot at returning to probation if you're working on your sobriety.
Yes, sir.
Here's the other thing. You've still got this case in Harrison County.
I understand.
And you've got let me tell you your dates so you don't miss those. You've got a pretrial conference on the 24th. Amber Shaw is your attorney there. Make sure you're contacting Ms. Shaw. Let her know where you're going to be.
I stay in contact with her.
If you don't follow through with that one, they're going to issue a warrant, and that's a level 4 felony. If you pick up more warrants, then I'm not going to have any choice but to sit on you, and you're going back to prison.
I understand. I do understand. That's what I'm saying. I just want one shot. I've been gone for 4 years, Your Honor. I just want one shot.
All right. So where are we here?
I am not doing it. Shut.
1 second.
Hamilton.
Oh, did the wrong one. All right. Do you need me to point to, you have Amber Shaw as a public defender. You want me to point to public defender here?
Yes, sir.
We'll appoint the public defender's office to represent you here. Make sure you call them every Monday until this case is done. Make sure you are here on May the 13th at 9 a.m. for your revocation hearing. I don't care if it's person or Zoom. You can do either one. contact your public defender or your probation officer also as soon as you get.
I will.
Because that person is going to make the recommendation on May that I'm going to follow. They say, listen, he called me once. He told me to take a hike and he hasn't called me since, then I'm going to put you in jail.
Yeah. I talked to Mr. Roach and he's like, look, as long as you turn yourself in, we're fine. We'll cross that line when we get back, you know? And I was like, yes, sir. You know,
I'm
that took a
struggling,
lot
guys.
out of me to turn
Struggling.
myself in on level 4, level 5, level 6 with the habitual. You know, that's looking at the rest of my life right there. I'm 44 years old, Your Honor. I'm so tired of doing this.
I 100% agree with you. Stay in touch with your probation officer, call the public defender's office, check in with them regularly. I'll see you May 13th at 9 a.m.
Thank you, Your Honor.
Welcome. Good luck. Candace Meredith, 2504 F5103. Ms. Meredith, and whoever hasn't heard this yet, but I think everybody has, as a defendant charged in a criminal prosecution, you have certain legal and constitutional rights guaranteed to you. I will now call your attention to these rights. You have the right to a public trial by an impartial jury in the county in which the offense was allegedly committed. If a trial is held, you will be presumed innocent unless and until the state proves your guilt beyond a reasonable doubt. You have the right to face all witnesses against you and to see, hear, and question and cross-examine those witnesses. You have the right to require witnesses to be present at any hearing or trial for the purpose of testifying in your behalf, and the court will assist you in this right by issuing subpoenas for such witnesses. You have the right to remain silent. You cannot be required to give any testimony or make any statement against yourself to anyone. You also have the right, if you choose, to be heard by yourself and by your attorney at any hearing or trial concerning the charges against you. Anything you do say, however, may be used against you. You have the right to an understanding of the nature and the cause of the accusations against you. And you have the right to a speedy trial. The court will at this time enter a preliminary plea of
Caesar just said you suck.
not guilty on your behalf. This will become a formal plea of not guilty 20 days after today's date. Unless after consulting with your attorney, a different plea is entered. We will also review your bond at this time. Your case will be available for public viewing on mycase.in.gov. If at any time in the future you lose track of your court date, can't find your attorney, don't know where you're supposed to be, go to mycase.in.gov. Ms. Meredith, did you understand those rights?
Yes, sir.
You are charged by way of information. Count 1, possession of methamphetamine as level 5 felony. Count 2, possession of methamphetamine as level 6. Count 3, driving while suspended as an A misdemeanor. Count 4, possession of marijuana as a B misdemeanor. Count 5, possession of paraphernalia as a C misdemeanor. The most serious of those offenses would be the level 5 felony, which has a penalty range between 1 to 6 years with an advisory sentence of 3 years and up to a $10,000 fine. We will enter a preliminary plea of not guilty, set you for a pretrial conference on May the 8th, your omnibus date, June 2nd, your final pretrial, July 3rd, and your jury trial will be August the 26th. The 3 pretrial conferences, you participate in those virtually, which means you maintain contact with your attorney, work on your case the best you can. If you lose contact with your lawyer, he or she is required to report that fact, and at that time, you would be deemed to have failed to appear. Ms. McCright, what is the state's position on Ms. Meredith, please?
Judge, the state's going to recommend a 5,000 cash only bond. She does have some criminal history. There's a pending case out of 31 DO1 2110 F6 708. There's also past pretrial FTA history.
Right, thank you very much. And Ms. Meredith, Brian Abel's here to protect your rights under Criminal Rule 2. Mr. Abel?
Judge, I'm going to ask you to release Ms. Meredith on her public cognizance. Understand the state's concerns about some prior criminal history and that pending case. I note that pending case that Ms. McCrack cited out of Harrison County is a non-supportive dependent. Looks like at some point a bond was posted there, and it looks like it was applied to the proceeds, and she's set for several review hearings down the road. So I would ask the court to for the release.
No.
For twofold reasons.
No.
I don't think we have any
No.
necessarily
I
recent
get some.
criminal history. I think on that pending case, it's just pending to give her an opportunity to make some payments. Because of that, I think the ability of the court to order her to pretrial services, I think we ameliorate any risk of harm without having an additional financial penalty really on whoever the beneficiary of that child support order is, Judge. So for those reasons, I ask you to ROR.
CJ, are you starting to fight a war? I mean, are you trying to start a war? Breathe through it. Zed.
Or never reported pretrials, or have a reported pretrial services. If you do a cash bond, I'd ask for a mortgage.
All right, thank you, Mr. Abel. Ms. Meredith, you have the right to remain silent. Anything you say, if you waive your right to remain silent, is being recorded and can be used against you.
Everybody knows what a mud sale is, right?
What I'm looking at here, ma'am, make sure this is the right person. It is. What I'm looking at is that you picked up cases once a year for quite a while. And I'm going to look and see why that might have changed, or if in fact it did change, because I don't see you in the Department of Correction system. But you had a methamphetamine case or legend drug case in 2018. You had a, where'd they go? Methamphetamine case in 2017, another one in 2020, one in 22. I haven't flipped to the third page yet. That's it. Let me see if that 22 case kept you in the custody for a bit. So maybe you have the right to remain silent. Anything you say, if you waive your right to remain silent, is being recorded and can be used against you. Is there anything you need to tell me right now, you think?
Just been sober for 3 years, sir. I have a 3-year-old at home, and my mother she was moved from ICU to CCU, so it's not as intensive as of right now. But I have had a lot going for me, and I have a 3-year-old at home.
I remember reading the facts of this case. Ms.
She's got a
Meredith,
3-year-old
with
at home?
the obvious addiction issues you have and had, I'm not going to release you today. I think you're a danger to reoffend. So I'm going to leave your bond set at $5,000 cash only today. You need me to appoint the public defender's office to represent you?
Yes, sir.
I will appoint the public defender's office to represent you. You can call them free Tuesdays and Thursdays between 3 and 4 p.m. And then we can look at recovery at some point in the future, but we're not going to talk about that today. All right, that's it for today. Thank you, ma'am. Anastasia Hall, 2501 F6135. And Brian, what are we turning? Why are we turning Miss Hall?
State filed a petition to revoke
I really freaking hate earbuds. They just fall out.
PCA, and that she was booked into the jail, and then at some point she was released. And in the interim period between her book and her release, well, I guess after that, I think probably the next day the state filed a petition to revoke bond based on this. Ms. Hall is in contact with me, and then looking at Circuit 3 case, I'm not really sure what's going on there. So it doesn't indicate they've sent a summons or anything like that. And I guess she was told to report to Circuit 3 and sign something to get an initial hearing set, which I'm not 100% sure what's going on there, but that's our next step is we address the warrant first and try to get something set in Circuit 3. But again, Judge, in Circuit 3, they did release her on her own recognizance. I understand the state's concerns about further additional charges, but I think we have, well, I say we, I mean, the court has within its power and discretion the ability to place her on pretrial services to ameliorate any risk of harm or flight. So that's what I would ask the court today, do today, judges. A, withdraw the warrants. I think we need to reset dates, but let me double check. And then reset dates.
All right. Thank you, Mr. Abel. Ms. McCray, what's the state's position today?
The judge, obviously, if she was out on bond enjoying freedom and collected a new case, who would request that the bond be revoked. And Your Honor, before you do move on to something else afterwards, we did have a motion to amend the information. We did amend the date of birth of the original information.
Judge, I think I talked with that to Ms. Hall. And my recollection was, I think the original information may have said 8/17. And Ms. Hall, you and I did go over that information. We spoke on the phone earlier this week, correct?
Yes, it's 8/16.
And Judge, I don't believe we'd have an objection.
Okay. All right, we'll allow the amendment as tendered. We'll give new dates because that's what we have to do anyway with the warrant. Here's the problem we have is Ms. Hall was in diversion in Floyd Superior 2 for a theft case. Was supposed to do the theft classes, didn't do that. They filed the motion to revoke October of last year, and that warrant's been outstanding since October of last year. Then she picks up a case with.
If I don't stream tomorrow, it's because I took this all and threw it right in the freaking trash can. And then poured water all over it.
Us in January, then she picks up another case.
Your Honor, that's not me. That's a different Anastasia Hall. I'm sorry to interrupt you, but
okay.
I've never had a theft charge until here.
She's a
Okay,
thief.
that's a
She
huge
stole someone
difference.
else's ID.
Yeah.
And it's worse than her own.
Is that because that was a pattern for sure? Okay, so then let me read the. Well, actually, let me read the pretrial recommendations. So that's why we cut her loose in January, because there was no criminal history to speak of at the time. So let me read this probable cause affidavit from the other case and see what I.
She could put an L in there somewhere.
I remember this probable cause affidavit. So Ms. Hall,
Yes, Your Honor.
alleged to have committed this offense less than 2 months after being released on the offense that we're here for in my court. So normally we're going to revoke bonds. That's a misdemeanor. This is one of the dumber misdemeanors I've seen when I read this probable cause affidavit the other day to sign it.
Dude, if I ever pick up a misdemeanor, I want the judge to say that. Mrs. Strada, this is one of the dumbest misdemeanors I've ever seen in my 30 years on this bench. That's all I want.
But we do have an option of pretrial services as a condition of withdrawing that warrant for your arrest today. So what I'm going to do today is order you as to withdraw the warrant for your arrest and order you report to pretrial supervision on level 1 supervision. Mr. Abel will give you the details on what level 1 means. So I'm going to withdraw the warrant for your arrest today. I'm going to direct you to call the probation department today. Actually, I'm going to direct you to show up today to begin your supervision. Where are you physically? Right now?
In Clarksville.
So you're going to show up today, call the probation department today and find out when they want you to show up. Show up and start your level 1 supervision until this case is completed. Sign and date this.
Judge, just for clarity's sake, you told her to show up in person and to call today.
Call today and find out when. Yeah.
Okay.
Just call them because they may not want you now. They may be closing early. If they're closing early, they say don't come yet. That's fine. I'll leave that to them. But yeah, call today. And then they're going to I want you there today, but I'll let them direct that. If they don't want you until tomorrow, until Monday, that's fine. But I want you to call today and make that appointment and then get down there and start your level 1 supervision today. She's talking about a ride. Is that ride going to be available? Okay.
Yeah, I was just am I getting put on probation? Is that what
so much,
is going on?
This is through probation.
Oh, okay. I guess you'll explain it to me. It's okay. That's all I was saying.
All right. That is it for today. Thank you, ma'am.
Thank you, Your Honor.
We got the due dates. May 8th pretrial conference, June 2nd final pretrial conference, or August the 26th is your jury trial. All those are on mycase.in.gov. Stay in touch with Mr. Abel. All right. Well, you can log off. Justin Reed, 2403 F6261. Check that out. Mr. Reed, you're here to talk about representation. Tell me about who you've talked to, what they're going to charge. Let me know where you work, all those things.
I was going to ask you, I got a bond on this case. Can I sign that over to Mitch or the lawyer I'm talking to?
Absolutely.
Okay, well then I'm probably going to have Mitch Harlan represent me then.
Okay, when they file that, make sure he knows or whoever knows. As soon as he files that bond assignment and a motion to release, I'll sign that and they cut a check pretty much right away.
Thanks, sir.
You're welcome. So the problem we have, Mr. Reed, is you're approaching jury trial July 1st.
Yeah.
I think probably a wise idea if I set new dates, but I would have to do that.
Things that please do.
Okay.
I'm not sure, Judge.
Yeah, please, I'm sorry. Yeah. I said, please.
It didn't come across that way, but thank you. All right. So I'll set you for a final pretrial conference on June 2nd. and your jury trial will be August the 26th. So June 2nd is your final pretrial. You and I are going to talk at the end of May, how that's gone hiring Mitch. I'm going to say May 30th at 9 a.m.
Yeah, he said as long as I can sign the bond over, he'd take the case. So he represented me before. So
if Mitch files that appearance, don't worry about May the 30th. But if you don't see that Mitch's appearance is on your case prior to May 30th, check mycase.in.gov, log in and tell me what's going on that morning.
Yes, sir.
All right, that's it for today. Thanks, sir.
Thank you, buddy.
Kenneth Wilson, 2502 F5. Oh, that's you. I forgot you were there. 2502 F538. And Mr. Wilson, tell me about your life right now. Where are you working? What are you doing? And do you need me to point to public defender, or you need more time, or what? We can do that. This is a fairly new case. So let's look at your dates. If I were to give you that same May the 30th attorney status hearing and set you for pretrial or final pretrial and jury trial in August, does that work for you, think? All right, you want me to do that? Yes, sir. All right, then we'll do that at your request. I will set the attorney status hearing May the 30th at 9 a.m. Final pretrial conference June 2nd. We'll address that on the 30th, and jury trial will be August the 26th. Okay. All right, you're good. Thank you. Can I like to add to? Brian, we have little sheets over there.
I think he wants an excuse.
Yeah.
No,
Oh, sorry. Yeah, go around the front of it. Go outside, turn a hard left, and come back into the offices right here. Okay. And they'll give you something. Yeah.
I also
all right,
want an excuse.
That's all I've got for the morning. Dr. Anybody else?
I don't have anybody else. Judge, can we go off record for a second?
Well, guys, we made it. We made it to the end. Thank you so much for coming out today and to see that crazy ending of that case where he's a 36-time felon. And we didn't know that. And he picked up a charge of battery when this happened. And then while he's on bond for this, he picked up 2 more charges of drug selling. No, you want more? You have to pay. In case, all right, April 14th. Hold on, I'm supposed to say some words. I'm looking for them. Mad Marathon Monday. April 14th is Mad Marathon Monday. So if I'm going to stream for 2 hours, like normal. And if you want anything longer, you got to pay for it, $1 per minute. So go here, though, and look at donation options. Because if you do it through YouTube, they're just going to take most of it, which is fine. It counts. It counts. Anyways, thank you so much for coming out, guys. I really, really, really appreciate it. I hope that you guys have a great day. I'm going to start OJ in about 4 minutes, which is a lie, but it's fine. I'm telling you, I'm going to start it in 4 minutes. Thanks, guys. Have a great day. See you soon.
Giggles roll like thunder loud. She stands out in any crowd. just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's love.